Yousoufian. I'm Judge Rob Lodersberry from Yakima, and I understand this case involves appeal and cross-appeal. If you'd like to reserve some time for rebuttal, I'm saying both sides. If you want to reserve time for rebuttal, please let us know up front, and we'll keep track of time for you. Okay, Ms. Zink, would you like to reserve some time for rebuttal?
Yes, Your Honor. I would like to reserve 5 minutes.
Okay, I will try to give you a warning 2 minutes before your time is up for your first argument. Those buttons in front of you, when it goes red, or when it lights up with green, it means you have 2 minutes left in your opening argument. And then when it's red, that means you're done with your opening part, okay?
All right, thank you.
You may proceed.
All right. Thank you, Your Honor. Good morning, Your Honors. If it please the Court, my name is Donna Zink, and I'm here to represent myself pro se in this cause of action, Zink v. City of Mesa. This is a 15-year-old case that has been ongoing since 2005. It was initially filed in 2003. And I'm not the greatest orator, and I am pro se, so I would appreciate it if you looked at the briefing, because it contains more of the citations and the arguments that I'm not going to be able to cover today.
You're doing very well.
All right, thank you. But I wanted to let you know that we as a nation, we are a nation of laws and our Constitution. And in Washington State, we have laws. And when you violate the law, let's say that you're a criminal and you violate the law, then you have to be punished. And because we have a sympathy factor, because we're humans, we've set out minimum and maximum penalties. And Mesa, in 2003, I began asking for public records. Now, the Public Records Act is a means by which the public can go out and force their agencies to give them the public records if they're unwilling to do so. And I saw something going on in Mesa that I thought was wrong. So I started asking for the records. Well, initially, Mesa did start to respond to the records, but then after a while, they started redacting the records without any reason whatsoever. They started withholding the records. They held a secret meeting, and they didn't provide the minutes that came out later in a Richard Nixon-style cover-up. And the more I went in and tried to tell them that there were laws against them doing this, the more they claimed that I was harassing them. And in the end, in March, and this is found at the clerk's paper 1571, I objected to them withholding the water meter readings because I had received them in the past based on an opinion of the Municipal Research Service Center. And when I objected, the city attorney told me at that time that if I wanted those records, I needed to seek a legal remedy. So, thinking that I had the law on my side, in April of 2003, I did. I went out and I filed this lawsuit. And that has caused this 15-year-old battle to begin. And in my opinion, this is the biggest travesty of the Public Records Act that I've ever seen. I have been treated like I was some kind of a villain. They claimed that I harassed them. In the end, the initial attorney said that I had overwhelmed them and that they were just too small to reply. This court, in response, overturned that decision and said that agencies are not too small to respond, that they have an obligation to provide the records. Otherwise, the people who live in the small agencies or have to deal with these small agencies are left to tyranny.
I want to move a little bit closer to the issues you raised on appeal. My understanding is that the trial court, after remand, awarded you $175,000 in penalties, and I think some of them may have been attorney fees too. And you're indicating that you believe the trial court erred in doing that, that there were a number of factors you think the trial court misapplied. And you understand, though, that on some of the issues that are being raised, the standard of our review is abuse of trial court discretion.
Correct.
And so would you let us know what it is that you believe, or how it is you believe the trial court abuses discretion in awarding you $175,000?
Yes, Your Honor. Actually, it's not in awarding. It's because he cut the penalty in half. And the reason I would like to point out that part of my argument is based on the city's arguments and what they're going to be presenting. So, but basically, I'll go into the details then. So, the penalty assessed is supposed to be based on culpability, okay? And every court around has said that. You guys said this in 2011. Amron v. Klamath said that. Wade's v. Gun Shop, and Yousoufian. It's a two-step basis. You figure out how many days the penalties, how many penalty days, how many days was the records withheld, and then you determine the amount of the per-day penalty based on the culpability, the good or bad faith of the agency. In this particular...
Yousoufian factors, but are the Yousoufian factors, are they exclusive or are they non-exclusive? In other words, can the trial court consider things outside the Yousoufian factors in awarding the per diem penalty?
According to the Yousoufian court, that's yes.
It's non-exclusive.
It's non-exclusive. In this case, the trial court determined that he would not go outside what the city asked him to do, and in fact, he did not use all of the Yousoufian factors. In each of the sheets, he told you which factors he felt was important, even though I think at one point he states that he did apply them, but he will say, you know, this one does not apply, and it's on those sheets. So that's how you award your penalties. And in this case, they were found to be egregiously withholding the records in many cases.
The trial court originally awarded somewhere like tentatively award about $353,000, and then because of the size of the city, the trial court used that factor, decided that it didn't want to bankrupt the city, so therefore cut the penalty approximately in half.
Right, and that's where we're
really
here.
what you're arguing here, right?
But he
That's
never,
correct.
the judge never entered an award in the larger amount. He just, that's where his calculations took him, and then he said, no, I'm not going to go there, and backed off. Isn't that correct?
Pretty much. First off, the first thing that he did was he went ahead and determined that SHB 1899 was retroactive, which is another portion of this whole thing, and it's a huge portion of this thing, but I wanted to put that off because it's very well briefed till the end.
And that's a question of law. We review that as a question of law.
Right, and I think I briefed that as best I could. And anyways, but yeah, initially he found $358,000, and he had made a glitch in his computer program, and so he was really trying to get closer to what Judge Acey had awarded. And that's another fallacy, because that's not how you award penalties. You figure out the number of days, you determine the culpability, what the bad faith was there no bad faith, and that's what you base your penalties on. He instead was working towards a figure.
Well, actually, the legislature, the statute only speaks of discretion. Yousoufian was a judicial decision that tried to provide guidance by identifying some factors. But in terms of the PRA itself, it simply says it's in the court's discretion, does it not? It doesn't speak of culpability or any factors.
Well, it talks about the bad faith, okay, and I think that's what the Yousoufian factors were meant to do, is to try and get some kind of an objective way for the court to review whether there was bad faith, so that you're not having subjective decisions made by judges. Because every case, even back way before Yousoufian, they said, like take Klamath, for instance, they said that it was based on, and I'm probably not saying that name right, based on bad faith. Is there bad faith? Is there good faith? Is there an absence of bad faith? Is there an absence of good faith? And since the legislature didn't go in and correct that, then that is the case law. So then you move forward, and you have all these cases coming forward, and they're not basing it on those issues. They're basing it more on how they feel about it, which is what happened here. And so they established the Yousoufian factors. And Judge Spanner went through and applied the Yousoufian factors, and quite frankly, most of the penalties are very low. And then after that, when he determined that there was a glitch and that he had actually awarded more penalties than he wanted to, that's when he cut the penalties in half. Now, like I said, the problem with our laws is that if the legislature did not mean for these laws to apply to the small agencies exactly the same. Okay, if they did not mean for these laws to apply to the small agencies, they would have said that. But they didn't. They said it applies to all agencies, and they did not distinguish.
Excuse me, but one purpose of making an award is to deter future bad conduct by the agency, right? You want to make sure you deter the conduct, the illegal conduct. Now, if the city the size of Mesa, or Mesa, is it pronounced?
It's Mesa.
Mesa.
Right.
Do you believe that the award of $175,000 to you, do you think that sufficiently deters the city from future wrongful conduct under the PRA?
No.
Why do you think that?
Because they weren't deterred to begin with. So I went in April of 2003 and I say, hey, I'm going to sue you, and I do. $5 a day. If they'd given me the records right then and there, we wouldn't even be standing here. The penalties would have been very low, but they didn't. They kept holding them for 5 years. And then in the end, they disappeared. Some of them I never even got. So it didn't deter them. You can only be deterred once before you violate. It's just like disciplining a child. You warn them. If they don't do it, you must discipline.
Question more clear. Is that is the $175,000, do you think it deters future conduct that violates
No, I don't. I asked them for records. I think I put that in one of my briefs, and the answer was they redacted the documents, and I had to go back in and threaten to sue them again, which is harassment, I suppose. That's what they claimed the first time, and they eventually did give me the records. But that should not happen. You should just be able to ask for the records and get them if they're not exempt. The other issue is that I think that if you allow the City of Mesa to get away with not having to follow the law, just like the larger agencies, then, because bad faith is bad faith, no matter what agency you're in. If you allow Mesa to get away with not following the law, you're telling other agencies, go ahead, hold on to these records. Nobody's going to hold you accountable. Thank you very much.
Please also let us know how much time you'd like to reserve once you start speaking.
Okay. Thank you, Your Honor. Ramsey Ramerman here today on behalf of the City of Mesa, and I'd like to reserve 3 minutes for my rebuttal. The case before the court, as you know, has 4 issues on appeal and cross-appeal. I want to focus my argument today on the middle 2 issues, the issues of the reduction, the court's authority to make the global reduction, and then the sufficiency of that reduction. These raise 3 sub-related issues. Does the court have the authority to reassess the penalties after coming to preliminary determination, or is it required to simply mechanically apply the Yousoufian factors? If the court has the authority to make a global reduction, is it allowed to consider the size of the agency and its limited resources? And then finally, is that penalty that equals 100% of an agency's annual tax revenue excessive as a matter of law? On the issue of what the court did, I'm going to skip over a few slides here, but what the court basically did is he went through and did a mechanical application of the Yousoufian factors. Then he stood back and said, hey, is this reasonable in light of Mesa's small size? And the court said, no, this is going to cripple Mesa.
What's the population of Mesa?
Mesa's population has about 500 people, so the original penalty amounted to about $700 per resident. And that is crippling, and it is totally contrary to what the Public Records Act is supposed to do. The court certainly had the authority. We know this simply by looking at Yousoufian itself. Yousoufian laid out these factors, but then it said, hey, these aren't exclusive, they may not all apply, and this isn't supposed to interfere with the court's discretion to set penalties.
$500 per resident sufficiently gets your attention so that in the future this type of violation wouldn't occur?
Certainly it's going to get their attention to make sure it doesn't occur. But we also, what we know from the history of the Public Records Act is that much, 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 much smaller penalties are sufficient to get agencies' attention. This case, as I said, amounts to, the penalty imposed amounts to 100% of the agency of Mesa's tax revenue for 2015. Amounts to $350 per resident. We can look at the Yousoufian case. There it was 19 cents per resident. Look at another egregious case, Marysville, Cedar Grove versus Marysville. There it was $2.40 per resident, versus here, Mesa, $350 per resident is certainly enough to get their attention, but it is also grossly excessive as a matter of law. Because, and this really gets to what is the purpose of the Public Records Act. And we know this, we simply look at the Public Records Act itself, and it tells us that the people of the state do not yield the sovereignty to the agencies that serve them, and the people insist on remaining informed so they may maintain control of the agencies they have created. This is really, I'd say, a codification of the social contract of democracy. We submit ourselves to government authority, agree to pay taxes, but reserve the right to vote to try and control how that is done. And the Public Records Act serves this goal by ensuring that the people have access to the information that they need. And ultimately, therefore, the Public Records Act is a tool to help the taxpayers protect their tax dollars. PRA's penalty enhances this through deterrence. It sends a message to agencies. Penalties are meant to send a message to agencies that it's going to be more expensive to withhold records than it is going to be to invest in compliance and make sure that you are complying with the law.
I'm going to fast forward you just a little bit if you don't mind.
No problem.
Are you suggesting then that as a matter of law, the PRA sets an upper limit per citizen of what a court can award as a penalty?
I'm suggesting that the court should do a comparative analysis to what type of penalties have been sufficient for deterrence and look at that and set, I don't think there's a strict cap, but this court has the authority, as we saw in Yousoufian, to provide guidance to lower courts to make sure that their penalties are proportional. And so we think that here, looking at a penalty that amounts to 1% of their tax income per violation, so 33%, is more than sufficient to serve as a deterrent. And
but wouldn't we be violating separation of powers if we were to set a cap? That's the legislature's job to set a cap.
Certainly if it was a hard cap, yes, but I think that you can provide guidance and benchmarks. Courts routinely review proportionality for penalties in statutory penalties. That's a common thing that courts will do, looking at general guidance here. And certainly you can look at the past opinions and look at how none of these opinions have exceeded more than 1%, and it's been sufficient to serve as deterrence.
Are you comparing this to like a motion for remediator, where even though the trial judge did remit the damages a little bit, you're still arguing that there's abuse of discretion?
Yes, we are. I am arguing because, we'll look at it this way. Let's imagine, I think we would all agree that if an employee had come up with some scheme to steal $175,000 from Mesa, the Public Records Act is meant to deter that theft or detect it. Yet the impact on the taxpayers here of this $175,000 penalty is the exact same as that theft.
I think in your brief at one point you analogized to punitive damages.
Yes,
and
Your Honor.
case law in jurisdictions where punitive damages are available. It's supposed to be a deterrent, but it's not supposed to go beyond what is needed for a deterrent.
Yes, Your Honor.
We would not violate separation of powers by suggesting to trial courts that it's in their discretion to consider how much is needed to be a deterrent.
Yes, Your Honor, and that is very much what I think that we should be looking at here. And I think that we can say as a matter of law, 100% of their annual tax revenue is grossly excessive of what is needed for a deterrent. They can't spend 100% on Public Records Act compliance. And what we get, when you get above deterrence, what you get is just waste. And this law is meant to protect waste, to turn the Public Records Act into a tool that where the acts of public employees, because they don't pay the damages, it's the taxpayers who pay the damages, to turn the Public Records Act into a tool to cause this type of waste is contrary to the intent of the law. This is not letting Mesa off. 1/3 penalty is a significant penalty. 1/3 of their annual income. That is massively, proportionally, that's the greatest penalty ever imposed under the Public Records Act when you take their size into account. This is a massive penalty, even at what we're recommending of $58,000. That is a massive penalty. There's also obviously attorney's fees on top of this. The $175 is exclusive of attorney's fees. That was made an additional ruling. We haven't appealed, and that was paid. So this is just the penalty. Mesa deserves to be punished in this. Since I came on this case, we stopped contesting liability. We've admitted Mesa needs to be punished. The question is, how do we punish small jurisdictions? Are small jurisdictions going to be punished grossly excessive of large jurisdictions? This court would never impose a penalty like this on a larger jurisdiction.
But at 1%, you're talking $1,700 here.
We have 33 violations here, so that amounts to $58,000. There's plenty enough to impose a significant penalty on Mesa. We are not letting it go. We are not letting Mesa go with this. They are paying a massive penalty in this case, one way or another. $58,000 is massive. When you have a teeny income, that's what we do.
Even if we accept your argument that the court had more discretion than it acted on, wouldn't the appropriate thing for us to do to remand it to Judge Spanner with some guidance and let him reconsider the penalty rather than for us to come up with some kind of arbitrary cap?
Certainly, remanding would be the normal way to go. This case has been going on for 15 years. My daughter was born about 2 months before this case started. It's ridiculous how long this has gone on. I think both parties would appreciate this court to enter something here. I think that the way that we've come up with the recommended penalty here does look to the prior cases, and this court has that authority. This is all on the written record. Judge Spanner was not taking new evidence. He was simply looking at, again, the record from the 2005 trial. And so I think that this court has that ability. We think that we need to make sure, ultimately, this is about the public's ability to control government. And nothing is less control than to allow an out-of-control employee to sacrifice a year's worth of tax revenue, $350 per resident. And that is what we're meant to stop with the Public Records
Your
Act.
argument be if the city council just said, we're not going to have a public records officer, we're not going to respond to public records requests.
I think that, again, there are going to be more extreme cases, but what we know here is after this lawsuit and after this court reversed in 2007, Mesa adopted new procedures. They got training. One of the first things I did when I came on this case was train the entire city council on public records compliance. They have not been sued since this lawsuit. Ms. Zink references a dispute which it goes into the scope of work product and attorney-client fee bills, which is something that I did the redactions on. I'd be happy to defend it, but the city said, hey, we don't even want to risk a lawsuit, just waive any protections and disclose those bills, which we ended up doing. But it's not a reflection of Mesa not taking the law seriously.
I'm curious how your deterrence argument works with the jurisdiction that just doesn't want to do it.
Well, if you have evidence that a jurisdiction just doesn't want to do anything, then obviously a greater deterrent is necessary. And I think that we can look at that on a case-by-case basis. But
You're saying that Mesa's current compliance and rehabilitation, if you will, since this case started, is a mitigating factor that the trial judge has to consider?
I think it is. I don't know if it fits into the mitigation aspect of setting penalties under Yousoufian, but I think it is strong evidence that a $58,000 penalty is more than sufficient to deter future violations. Because
1.5 minutes of your opening argument.
so I think that I think we know in this case, I'm simply saying if there was concern that maybe 58,000 wasn't going to be enough to motivate them to change because they hadn't changed, then I think you could be pressing me and saying, hey, why do we think this is not enough? But here, there's no reason to think that is not enough. And I think that, so I would analogize, again, look at, consider the Court of Appeals, collectively the three divisions have, from what I can tell, about $18 million budget. So this is like a $6 million penalty on the Court of Appeals. Is that going to motivate any agency to change their tune? The answer is absolutely yes. How high do we need to go? The Public Records Act is supposed to protect the people. It is not supposed to be a tool to waste. And I would say again, this is a growing problem because now that we have per-page penalty possibilities, these massive penalties are possible in any case. And what we end up seeing is an inability to settle these lawsuits. Because they have the pie-in-the-sky hopes, the agency can't agree to a penalty like that. This court has seen it with some of the cases. I think it was Strand that had a $10 million penalty demand. We need to make sure that the law serves its purpose. Again, punitive damages is a very clear example. They don't actually impose punitive damages on governments because the taxpayers pay them and it doesn't serve the purpose. But when they do impose them on individuals, they look at what are their resources, and that's what we're saying. Mesa has extremely limited resources. We should not turn the Public Records Act into a tool of waste. It was meant to prevent waste, and ask this court to affirm the court's authority to make the global reduction, but find that in this case it should have been greater given Mesa's limited resources. Thank you.
I don't want to take his time, but when you get up for your rebuttal, could you do me a favor and provide me with a record citation for how you calculate the MRSC misunderstanding by the judge as increasing the penalties by a third?
Yes, Your Honor.
I wasn't able to track that.
Okay. Yes, Your Honor.
Thank you, Your Honor. First, I'd just like to go over a couple of things, and then I would like to go right to that point that you just brought up. One, I'd like to point out that in the Yousoufian factors, deterrence is not a major factor. It's one of 16, and it's an aggravating factor. What they actually said was that it takes more to deter a large agency than a small. Also, the punishment has already been set by our legislature. It was set between $5 and $100. Now it's up to $100, so that's going to depend on whether it would be able to apply it retroactively. But they've already said that. They said if the maximum is $100. If this court goes in there and now says that the maximum is 1% of a budget that hasn't even been defined, he jumps back and forth between the budget from the taxes, yearly taxes, to the unreserved budget, to the... It's not really been refined. He just throws in there this budget that this is what Mesa can afford.
Well, aren't we legislating if we set a cap? Aren't we legislating?
That's my opinion, that you are legislating, that you'd be legislating from the bench. So, but they've actually, the city of Mesa's probably paid their city attorney more money than they want to pay me at this point. But that's not the point, because the point here is that the law is the law, and it is unfortunate that they chose to violate the law, and they did so in such a manner, and they did ignore. They ignored the whole time. But I'd like to go into the linkage argument, and the City of Mesa argues that there's two different places in there, and that the first one was the MRSC memo, and then he increased it by $15. And then the second one that he went in, he says that that's the secondary period, and then there's the quaternary period. And he says that in the quaternary period, that was also based on the MRSC memo. And this is false. Number one, the judge went in there and said in the secondary period that after they got the MRSC memo, that they were alerted to the fact that the addresses were not redactable. The addresses, the phone numbers, and the names. Okay, and that they did not do anything to fix that issue. The quaternary period is based on the fact that even after the trial court ordered them to release the records, even after this court in 2007 sent it back to determine the violations and the penalty days, they still would not release the records. So even though they had all this training, they still wouldn't release the records. So he increased it to $20. Now, the little blip that he had in there about the $20, all he was saying is he set them both at $20. He didn't set them both for the same meaning. And also it says here in a case, it's from 1963, FERRE, which is FERREE v. Doric. It says statements at variance with the findings cannot be used to impeach the findings of judgment. So what the judge wrote down in his findings is what he meant. So the secondary is not the same as the quaternary, and the penalties for those two sections were based on different issues. And as to the City of Mesa's argument about, the ballooning this and making so much on this, I would like to point out that in a case of Waits v. Gun Shop, that there was 234 days of penalties that amounted to $500,000. And one of the reasons why the penalties went up so high was because they refused to release the records even after court ordered to do so. And the last thing I want to say is on the linkage argument. And the city argues that there is no linkage argument back in 2003 for them to turn to. And I would say that this court needs to go to Tacoma Public Library v. Wosner, because in that, not only did they discuss the linkage argument, and that is between pages 215 to 224, but they also discussed the issue of the Freedom of Information Act and how it does not apply in the state of Washington. Because in the state of Washington, you must have not only a privacy interest in the documents, you must have no public interest. And unless you have those two things, you cannot withhold the records. There's no balancing. So both of those issues were discussed, and that was in 1998. Had they but looked and gone to somebody for direction, they could have gone to MRSC, they could have gone to the Attorney General, they could have gone to their city attorney. There was lots of things that they could have done in order to avoid what has happened here in the City of Mesa. I guess I was talking pretty fast. In closing, I'd like to say that allowing Mesa to escape the strict mandates of the PRA while holding larger agencies accountable erodes the people's confidence in the judicial system, that all are treated equal, and that the PRA will be helpful in all circumstances. And do you guys have any questions? All righty. Thank you very much.
Thank you, Your Honor. So the issue on the number of days affected by the increase of penalties based on the MRSC memo is a debate on whether that increase applied for only the secondary period or also for the fourth period that the court imposed penalties. It increased it from $5 to $15 for the secondary period. It then goes down to $1 a day for the third period. And then the fourth period, it goes back up to $20. And the issue is whether that $20 increase back up to $20 in the fourth period was based on the court simply imposing the rate that was at issue in the secondary period, which is based on the MRC memo, or whether there was a new justification for that increase. And the court, in its findings, is confusing. There's 4 violations that are affected by this. In 3 of them, the court said only a first and second period, which doesn't really even help. But we do have, for the fourth one, the court got it right and said, okay, so then it's going to go, and mentions all 4 periods. So it's clear that it was trying to do that. But I asked the court about this at the hearing, and if you look at this, this is at page 33 to 34 of the June 29th hearing. And I said, the court said, okay, so I'm going to be increasing this. That's $20 days for each of these periods. The tertiary and quaternary period, correct? No, that is for the secondary and the quaternary, however you pronounce that word, period, not the tertiary. But again, the court is addressing this. What were you increasing for the MRSC memo? And he says he agrees that it's for the second and fourth period. So that's where the dispute on the number of days are, and then that affects how big that increase was. The position that we have is the court simply said after that MRSC memo, it's going to be $20 a day, except during the appeal period of the $1 a day. Yes, what had happened is that the city, in a separate public records request that dealt with attorney fee invoice, that asked MRSC, can we redact identifying information in these attorney fee bills? And MRSC said, there is no general exemption for identifying information that's going to apply here. But it went on to say, here are some examples where you can redact identifying information. And those happen to be the exemptions that the city was relying on for its exemptions in these other documents, in this other request. And the court said that given this knowledge, the city should have reassessed its exemptions. We think that is an error. The facts do not support that, given that this memo that they're supposedly relying on affirmed the exemptions that they were relying on. And second, we think the court abused its discretion in the amount of the increase, even if some increase was valid, because going from $5 to $15 a day, because it affected so many days worth of violations, ended up increasing the penalty by 33%. Simply on that ruling, if any increase was warranted, it should have been significantly lower than that.
So even if we were to accept your argument that the court's finding on that was not supported by the evidence that was before it, that would reduce the penalty, but it would still be more than $175,000 that ultimately imposed. So how would we know whether Judge Spanner still, even if you were corrected on that score, would still impose a $175,000 penalty?
Well, the court was looking at this ruling at the time that it also decided to reduce it in half. So I think that you would take a third out of or reduce the $175,000 proportionately. I think that would be a reflection of what would be appropriate if the court agreed with us on the MRSC memo, because the court was considering these factors together. Again, and as we've said, I think the $175,000 penalty is simply contrary to what the PRA is meant to do. If this is supposed to be control of government, control means that you are avoiding this type of waste. It is not supposed to facilitate. These are paid by the taxpayers. If these were paid by the bad actors, then we'd want to punish them differently. But these are paid by the taxpayers. Ms. Zink started this quest because she thought the city was abusing the taxpayers of Mesa. Yet we're going to inflict a much worse abuse by imposing an entire year worth of salary based on the conduct of employees. This is not letting Mesa off. No one is escaping a $50,000 penalty. This is
quite a bit over your time.
Okay.
Can I ask a question?
Yes, please.
Did you, it seems to me that whenever we decide this is going up to the Supreme Court, did anybody try to go directly to the Supreme Court, or did you just start here?
We just started here, Your Honor. We did not. We discussed it, but neither one of us ended up filing something to push it up to the Supreme Court. And so.
Do you think it would make sense for us to certify it to the Supreme Court and save you a step?
I think that this is an issue of trying to get whether there is some type of soft cap on penalties is a significant statewide issue. Not that I want this case to go on any longer, but I'm not sure that we can stop that. I think that, but I do think this court has the authority as well in providing guidance to lower courts. And again, this is meant so people maintain control of the agencies they've created. How are we maintaining control with this type of remedy? Thank you, Your Honor.